Thank you for seeing us this morning. My name is Sally Barry. I'm the Director of Probation Services. I have with me Audrey Rocco. I'm the Deputy Director of the Adult Unit.
Okay, go ahead.
So as you're aware, over the past couple years, the court has been seeking out grant and program opportunities that would help the county reduce the prison population by diverting low-risk offenders from the prison into community-based treatment alternatives. Well, because of the budget impasse, funding opportunities have been somewhat limited over the past couple years. However, PCCD did announce federal funding availability that's specifically directed to pretrial diversion programming for drug and alcohol offenders. So the court is requesting to take a stab at the opportunity. The funding is pretty limited. I believe the cap per, it's very competitive. And I think the cap is about $236,000, I think is what the cap on that is. The grant that we prepared that's in front of you is to enable the county to identify and divert those low-risk offenders with drug and alcohol issues from prison to community-based treatment programming. So the goal would be to identify those particular offenders at the point of arrest, at the site of central booking, and provide them with the treatment and the follow-up supervision that they would need to get themselves straightened out and stay out of prison. The grant is specific to funding of salaries and benefits of two individuals. The first individual would be an assessment treatment coordinator who would assess the offenders that come into central booking through the use of the probation department's newly implemented risk and needs assessment tool, so that we are identifying that we're weeding out the violent offenders, and we're just taking a look at those offenders that would be most appropriate for jail diversion. And then the other thing the treatment coordinator would do would be to complete the PC-PC3, which is an assessment specific to the drug and alcohol world, to identify that particular offender's need for treatment, be it detox, be it inpatient treatment or outpatient treatment, and then make the appropriate referral and coordination for that treatment service within the community or in inpatient treatment. The second position would be an officer, a probation officer, that would supervise those offenders who are placed on bail supervision to ensure that they are complying with their treatment, the treatment component. There'd be a collaboration between the treatment provider and of course, court would assist with the coordination of that treatment and any other conditions that the magisterial district justice or the common pleas court issued on the offender as a condition of bail. So it would definitely be a coordination between the district attorney's office, between the public defender's office, between the prison in some cases, because we do recognize that this would be a position that at least the assessor and coordinator position would be one that would be primarily during normal business hours. So there are offenders that are going to get arrested outside of those normal business hours, and the expectation is that that assessor would then go down to the prison and do the assessment at the prison, and maybe they wouldn't be directly diverted from prison at the point of intake into central booking, but they certainly wouldn't be sitting there for several months at a time before they're made eligible for bail. We do have the support of the Criminal Justice Advisory Board. I have discussed the program with the district attorney, who's in support, the warden, and Jim Dunmore, director of drug and alcohol, who are all in support. Statistics show that upwards of 500 plus offenders are coming through central booking in a month's time. It's a lot of people. We don't identify that all of those individuals would be eligible. I would like to suggest that the probation parole violators, by the time they're getting to central booking, our office has done a decent job at providing alternative opportunities that are alternative to prisons, as much as we have available to us in the community at this point in time. So we would primarily be looking at those individuals that are coming in on bench warrants, those individuals that are coming in on new charges.
What would your expectations be at
at the completion of this grant?
A couple things. We expect, and I might be being, I might be low numbering it, but we're hoping to at least serve 500 individuals a year. So at the end of 2 years, a total of 1,000 individuals. We're hoping to reduce prison population by a few hundred a month. That may be a high expectation, but that's what we're hoping for. And then on the back, so we're looking at doing that from the front end. We're also looking at reducing the prison population on the back end. And what I mean by that is, if people are successful in a bail program, a bail supervision program, they're following through with treatment, they're managing to not get rearrested while they're on bail supervision. If I'm a common pleas court judge, that's showing me that they are able to be treated and managed in the community and don't need to go to prison. So if at the time of sentencing, a probation officer and that offender can come in and they can show how successful the offender's been during the bail supervision part, I don't want to speak for the court, but unless there are mandatory prison sentences involved, that could absolutely result in a person being placed on electronic monitoring as opposed to going to jail. That could absolutely result in a person spending less time in prison than maybe what the judge would have done initially had they not proven themselves to be successful prior to sentencing. The day reporting center won't have. They won't have someone, they don't have a treatment provider at the day reporting center. They have drug and alcohol education, but they don't have a treatment provider. They would divert those individuals like this program will do into our community, because our community currently has what I would suggest to be enough drug and alcohol treatment providers, and we certainly don't want to take business away from them. Depending on how many individuals that we're looking at putting into the day reporting center, you know, and this may be a presumptuous and early conversation, but you know, I'm anticipating we would at least have 2 probation officers in that position, as part of the day reporting center. This could be one of those individuals.
Is this for first-time offenders only?
No.
So they could repeat this program if they were a reoffender?
Yes.
And my third and I think final question is, must this treatment or diversion be ordered by a judge, or who makes that decision?
Yes. So that would be where the coordination with the magisterial district justices would come in.
Would the district judge have that authority?
Yes. Yes. The judge, it would be either whoever is ordering the bail supervision in this case, so sometimes that's the MDJs, oftentimes that's the MDJs, but if it gets to, for example, if it's a bench warrant and that bench warrant goes before the common pleas court judge, then the common pleas court judge would determine whether or not that person was appropriate for bail. And again, this has been coordinated with the president judge, and I know he's spoken to the other judges, and I believe it's safe to say that we have support of our bench.
Would this be
Grant, is that a PCCD grant?
It is it's federal funding that's being filtered through Pennsylvania Commission on Crime and Delinquency.
And how confident are you that you would receive this money if you applied for it?
I'm not. I think that our proposal is right in line with state initiatives. However, it's competitive. I think they're going to allow seven funding.
I would make a motion with a comment. I see this as an opportunity to fund something that could facilitate the day reporting center, and we have 2 years to see if it works. And I would like part of my motion to be that we revisit the topic at the end of the 2 years for quantification to make sure that it is outcome based.
Well, just as a clarification, we'd have to revisit because if we have no additional funding, we'd be deciding whether we want to continue those positions. So I'm assuming that would come up automatically.
Well, I would like it as part of the motion because oftentimes things get blended into budgets and commissioners change and people forget, and so if it's a part of the official record, it's not going to go away.
Is there a second to the motion?
I need clarification on the motion, Mr. Chairman. Just, if you would just restate it. No, I think I'd just like it restated so that I know what I'm seconding.
Sure. I have made a motion to apply for this grant, and on the condition that we get it, that we then revisit it at the end of 2 years so that we can look for the outcome based that we were told we would get, for instance, 100 a month reduction.
I'll second that motion, but I do have some things that I'd like to comment on.
You know, why do we have to make things so complicated? But I would like, I'm supporting this, by the way, but I'm reluctant to take the burden of complicating it with things tacked on, if we get it, and if it, and what are the outcomes going to be. When we have an automatic checkpoint with the budget process, if there is no money for those positions, we have to decide whether, you know, the outcomes have warranted budgeting for them. So I think it's excessive to complicate a motion when we'd have a simple process, but I will not hold up the motion by, I'll support it, but with reluctance. Go ahead, Bill.
Okay, well, I, on the other hand, am not excited or really expect to support the motion for this reason. And I understand your comments, Commissioner Phillips, about we'll look at it at budget time, but you know, things don't happen like that around here. And listening to Director Barry, it's her anticipation that these positions will continue no matter what. And I feel I am interested in lowering the number of folks in our prison, and I'd like to be proactive, but it has to come at a reasonable cost. And we have talked, this board has talked at length about mandates and how we get entrapped in these things through accepting grants and funding. And I feel that if someone doesn't eventually take a stand against this, it just exponentially increases costs. And we're talking about a department here that, and I'm not pointing blame at anyone, but that has blossomed when it comes to what it costs the taxpayers. And I think we ran about $900,000 over budget in 2015.
With all due respect, Commissioner, we're talking about two separate units in that department, two totally different funding streams for those units. One is juvenile, one is adult. And with all due respect, it's not fair to pass judgment on an adult unit's expenditures based on where we're at in the juvenile system.
Okay, fair or unfair, I still have to be accountable for coming up with the money to pay those bills. And I'm the one that, with all due respect, spent what little political capital I have in Lebanon County increasing the taxes 32% to afford to do these things. So I will be respectful to your rationale that it's two different divisions, but it's still part of the cost that I have to support. So, also, in addition to that, we have, I think, the most aggressive labor agreement with your folks of any other in the county. And we're looking at 5.5% salary increases due to a binding arbitration that we had no decision in. We also had the hours worked increased from 35 to 37.5 during the negotiations process by a court order, which we had no control over or no say in. And I want to protect taxpayers from requesting a grant that will support two positions for 2 years, expand the department, and have us faced with those increased costs 2 years from now. So I'm prepared to vote against it. And I'm sorry to put you through this because it's probably a long shot, or at least you indicated that you would get it anyhow, but I don't want to take the risk. Somewhere along the line, we have to break the cycle of, oh, let's take this money from the state and federal government, who are both broke already, that they don't have, money that they don't have, so that we can start a program so that 2 years from now, when that funding goes away, we're going to ask the homeowners to again support it. So that's all.
Thank you. The only thing I would add to it, or maybe it's not necessary to, is that any innovative programs that we can use to, help rehabilitate, reduce this generational incarceration, all those things that we're all trying to improve on. I think it's worth, investing in, and appreciate you going for the grant money. And we do know that all this stuff comes at a cost to the taxpayer, but hopefully the benefits will be realized that we'll say, we're glad we did it. And if after 2 years, we'll all be here, and then we'll remember this moment, and if this thing falls flat and isn't productive, then we'll have the opportunity not to fund it further. So, and we wouldn't want to, and nor would you want to, if it's not working. So, anyway, anything else? Call the question? You good? All in favor of the motion as we have it, please indicate by saying aye. Aye.
I'll say aye, but you have totally confused me. And I think the math is in my head, and that's what I'm going on, reducing the 100. But I don't know where they're coming from, if not from probation and parole, because those are mostly either mental health or drug and alcohol offenders.
We
Want
have,
to take another shot at it?
sure. We have 500 plus offenders that are coming through central booking. 250 of them are not probation
It's
providers.
per month.
Per month.
So you're
they're
going after the
coming from-
250 not that are in?
Yes. I mean, I'm not saying that we wouldn't be looking at all, for us to say, oh, we would never look at the probation pro violators. I'm just saying realistically, I am confident that our office has taken steps at looking at whether or not we can divert that person from prison when it's possible to do that. So we would be targeting new charges and individuals that are coming in on bench warrants from, possibly probation pro violations, and also bench warrants for new charges for failing to appear for court. So we'd be targeting that population, which is not being targeted now.
Got it. Thank you.
Hanging, I said aye to the motion.
Mm-hmm. Aye.
Motion opposed?
Aye.
Split vote 2-1, the motion carries.